Thank you, Lauren, and a big welcome from me, Liam Colley, to this, what I'm told is a hotly anticipated panel on calculating damages in class actions. And I'm very privileged to be chairing such an esteemed panel of fellow experts. Greg Harman, a veteran testifying economist at BRG, Vivek, a rising star at Cornerstone Research, and Tasneem, Azad, who heads the economics disputes practice of Duff and Phelps. And for those who don't know me, I head the economics practice at AlixPartners. And between us, I think we are involved in all of the sort of leading antitrust class action cases over here. And actually, Tasneem is going to help us lift our gaze from the small world of antitrust with her experience in securities and consumer actions. And we bring perspectives from both sides of the V and from multiple jurisdictions. And we're going to try and muster all of that to bring you a common view that hopefully predominates over all of our individual views. Whether we'll achieve that, economists are not famous for violently agreeing all the time, and there are four of us, but let's see how we get on. It's a big topic, so we've decided to focus on three key areas: commonality, different types of evidence, and specific challenges that the experts face. So let me just kick off with a few comments on those themes. Commonality, well, it's all rather up in the air still, isn't it? With Merrick's, the Court of Appeal and the CAT can't agree even on whether pass-on is a common issue. But you know, when I look at Merrick's, I think, you know, wherever the Supreme Court comes out, I think we can safely conclude that the bar over here is still going to be very low. If you look at the range of individual issues, the potentially huge range of individual losses on Merrick's, driven by wide variation in pass-on rates, probably across sectors and across business models, huge variation in consumer spend, and not to mention the impact of cardholder benefits. I, for one, got the impression that, you know, had the claimants perhaps worked a little bit harder, rightly or wrongly, in terms of the legal test, but had they worked a little bit harder in terms of data availability, and had they proposed perhaps a slightly less blunt distribution model, then the class may well have got certified. And I think what we can agree on is that the bar over here compared to the US is much lower. And I wonder whether my fellow experts share a little bit of my jealousy of our US counterparts, because when they're dealing with certification, I think they've got far clearer, bright lines. There's tried and trusted techniques for evaluating common impact, and they get to do that with an abundance of data post-disclosure. Over here, we're left to speculate a little as to whether we're going to have enough sort of petrol to put in the engine of our model in terms of data, and we have to deal with you know, significantly more granularity. So those are important issues, and actually Vivek in particular is going to pick up on some of those in a moment. Turning towards types of evidence, well, what again is clear is that economic evidence is obviously very important on these cases, but what we also know about economic evidence is it can be very complex. And as we see these cases come through the courts, we see the courts are able to deal with complexity. We saw that on BritNed, the first antitrust damages case to go to full judgment in the UK, and a bit of a lodestar for us in this space. But we've also seen a tendency for the courts to be somewhat attracted to simplicity. So on BritNed, the claimant's singular focus on complicated regression analysis, I think, was a little outflanked by the defendant's mix of that sort of analysis with simpler, more tractable accounting margin evidence. And what that suggests is that the experts need to be a little wary about putting all of their eggs in one basket and overcomplicating things. And if it wasn't obvious from the Microsoft test, should be very wary of relying on theoretical models that are quite removed from the direct evidence. And we are seeing some of those in class action as well. And then on pass on, all that was on overcharge. On pass on, if you look at Sainsbury's in the cat rather colourfully downplayed the role of, or the probative value of economic theory on pass on, preferring, not unreasonably in my view, to focus forensically on the commercial practices of the direct purchaser in question. So again, that suggests that these techniques that rely on broad brush strokes to use economic theory to fill in lots of gaps across different types of business models to pass on may actually struggle when you get to trial. In other cases, other types of evidence are going to dominate. I think we're going to see classes of businesses coming forward, for example, in the tech space, where you're going to need valuation skills, and in the consumer space, as we'll hear, bespoke consumer research will play a significant role. And we're going to hear from Tasneem and Greg on those points in a moment too. And then finally, some challenges, specific challenges that the economic expert faces. I'll touch on two, and we're going to hear from all of the experts on these. The first one, granularity. So I think we will inevitably deal with a lot more granularity over here going forward. And let's be clear, economists are not fazed by granularity. We actually relish it. We're quite an optimistic bunch. We have lots of tools, and complexity is not a problem. But there is a danger sometimes of overreaching, of assuming you can build a model that can handle all sorts of complexity. You know, a bit sort of like Lord of the Rings. You can have one model that will rule them all, answer all the questions, address all the permutations, tell you how the overcharge varies, depending on whether the vehicle was painted blue or pink with yellow spots. But the reality is that to do that, you actually risk, the model actually not working properly. There's a trade-off between granularity and the statistical power of the model. And the more variables you put in to handle granularity, the more individual questions you ask, the less certain you can be in the answers to those questions. And this is important because both experts have to manage the risks of coming up with false positives or false negatives. So the defendant must be careful of not assuming that, you know, if their model happens to show no overcharge, that doesn't mean they've proven no overcharge. Absence of evidence is not necessarily evidence of absence. They've got to also show that their model has the statistical power to find the overcharge if there is one. And that issue, unfortunately, wasn't properly ventilated on the Britneg case I referred to earlier. On the other side of the coin, the claimants expert have to manage the risk of false positives, sometimes called the Bigfoot fallacy, on the basis that just because you've found a large footprint in the snow doesn't mean you've proven the existence of Bigfoot. You've got to rule out alternative explanations, alternative confounding factors. You've got to show your model isn't driven by a bias that's giving rise to the false positive. And more happily, that issue was properly ventilated and well looked at in the Britneg case. So those issues are important. And then finally, data availability. This is a massive issue, obviously, on merits, rightly so. It's rubbish in, rubbish out with these models. And we will wait with interest where the Supreme Court tells us the line in the sand is in terms of showing evidence of availability at certification stage. One final remark I will make, just going through the CAT judgment, is that I was struck when we got to the bit where the claimant's expert said at one point, and I'm paraphrasing, well, we'd like to have gotten hold of that data or done that extra analysis, but we really didn't have the budget for that. Well, funders, listen up. maybe there's a need for more budget earlier on, and actually experts speak up. Maybe it's incumbent on us to make clear that what position we need to be put in so that we're more confident that there will be the petrol for our engine. So I'm going to stop there before I get into even more trouble with various solicitors and barristers. And I'm going to hand over to Vivek, and then you'll see me again at the end for some Q&A. Thanks.
Thank you so much, Liam. What I wanted to do today is spend a little bit of time talking about the commonality requirement that Liam alluded to. As you all know, a preliminary step in class or collective actions is determining whether the action will be permitted to be brought as a class action for a specified class of claimants. And this requirement is applicable in a number of jurisdictions in the spirit of the title of this whole symposium, Global Class Action Symposium, right? I think we can talk about the relevance of this in a variety of jurisdictions, and I will. For example, in the UK, the claimants seek a collective proceedings order, or a CPO, from the CAT. And in the US and Canada, plaintiffs seek a motion for class certification. So at this stage of the litigation, the focal area of inquiry is the commonality of antitrust impact, injury, or harm among the class members. And this has been referred to as common impact. So in particular, the claimants, often through expert analysis, need to show that sufficient proof is available at trial to prove that antitrust impact is common to all members of the class. And while this requirement was originally articulated in the US in the linerboard matter, the same language has been considered both in the UK and Canada in class decisions. So, it is this requirement that makes class actions or collective actions more complex relative to actions that are brought against one entity. And this is because, the proposed class members could be very differently situated, right? Consider a price fixing matter, right? They could have the class members may have purchased different products at different times from different retailers to different channels, much like, Merrick's. In other words, the heterogeneity of circumstances in which the at-issue product was purchased can vary significantly across class members. And if that is the case, the important question is if the alleged anti-competitive conduct affected each member of the class in a common way. And as importantly, at least for us economists, what is it that the economists need to be able to demonstrate to respond to this important question? Now, as it turns out, what the economists are required to demonstrate varies by jurisdiction. And moreover, this requirement has evolved in various jurisdictions over time. In the UK, given the relatively recent introduction of the class action regime, this issue has been the core of sort of the debate in Merrick's. But before I go into the state of play in the UK, let me talk a little bit about sort of the US and Canada. And I think it's relevant. I think the US is relevant because although the regime is different relative to the UK and Canada, it is the most mature regime of the three. So there have been sort of approaches that have been tried and tested in the US, which serve as good learning ground for us. Canada is obviously relevant because the UK regime is similar in many respects to the Canadian regime. And importantly, there have been some recent decisions in Canada which really shed light on what the economists need to do to demonstrate commonality. So, very quickly, the US, right, a central question in class certification is whether all or virtually all class members are impacted by the conduct at issue, right? So what the claimant economic experts needs to demonstrate is that common evidence or a common methodology exists which can establish antitrust harm flowing from the alleged conduct, and importantly, to all or virtually all class members, right? And in the US, as Liam again pointed out, there is discovery. So, economists often have access to very granular data to be able to demonstrate this commonality or lack thereof. And, there is a robust literature, right, on whether and in what circumstances various economic modeling strategies suffice to meet this common impact burden. And in the interest of time, I'm not going to go into the nuances of this debate, but at a very high level, right? So one approach the claimant experts use is to try and argue that although prices are diverse because of the kind of heterogeneity that I spoke about, they are all a part of this price structure in which all prices move together, right? So the argument is that if there is evidence that one price is impacted by the alleged conduct, via this price structure, all prices must have been impacted. And therefore, all or virtually all class members are impacted. And the way the claimants experts do this is by saying that, look, there is a list price all other prices are benchmarked to this list price. If the list price has moved, and you can show that all other prices co-move with the list price, you have met your burden. And the empirical way in which this is done is by using techniques like correlation analyses, right? Or in more recent cases, more sophisticated time series analyses, right? And I think one sort of issue with, one challenge with these kind of analyses is that correlation does not imply causation, right? So very simply, prices may be moving together, but due to factors unrelated to the alleged conduct or the existence of a price structure. And that is the debate between the defendant economists and the claimant economists with respect to these analyses. Another sort of approach that is commonly used are regression analyses. And as we know, regression analyses, when done properly, allow you to isolate and identify the impact of the alleged conduct while controlling for other factors that may influence price. Now, the challenge in using regression analyses to address common impact, which means to address whether all or virtually all class members are impacted, is that the regression ultimately measures an average effect, right? And this is sort of, to sort of tie this in with what Liam was talking about. Oftentimes, right, claimant experts can use sort of more sophisticated regression analyses to account for this granularity, right? You can, for example, control for claimant characteristics. You can control for, in Liam's example, whether the car was painted pink or blue, right? But ultimately, there is a tension here, right? One, do you have enough rich data to be able to do that and give you statistically powerful, help you make inferences that are statistically valid? And second, right, even if you're able to do that, right, you're still establishing an average, right? So ultimately, a regression is an average effect, either across all class members or a subset of class members. And the question is that enough to establish that each and every class member is harmed, right? And that is sort of the debate that, the defendant economists and the claimant economists often engage in. And there are a number of empirical ways in which you can test these models in order to engage with that debate. Interestingly, like moving over to Canada, which has a lot more relevance to the UK, this all or virtually all standard, right, is not applicable in Canada. In fact, there's sort of this recent decision by the Supreme Court of Canada that came out, the Godfrey decision, which explicitly rejects the standard, the all or virtually all standard. And instead, the decision says that what the plaintiff expert methodology needs to do is it needs to be able to establish that loss reached the requisite purchaser level, right? Or in other words, one or more of the claimants at the purchaser level, right? And I'm going to refer to the standard as the one or more standard. And that certainly is a lot more lax than the US all or virtually all standard. And in some sense is also lax. For those of you who are aware of the Microsoft decision in Canada, which the CAT cites in Merrick's and it's cited in Pride in a number of UK cases, right? I think the Godfrey decision set the bar in Canada for the claimant experts a little lower than what it was with the Microsoft decision as well. However, the Godfrey decision does acknowledge that while an aggregate methodology, damages methodology, may be sufficient for the purpose of class certification, at the common issues trial, right? If the judge wants to use this aggregate damages provision, the judge has to be sure that either all class members suffered loss, or the judge can distinguish between those who have suffered loss and those who have not. So that's sort of an important qualification here. Now, in Canada, like the UK, there is sort of no discovery at the stage of litigation, right? So again, the Canadian economists, or those of us who have sort of done work in Canada, we don't have access to data in order to do the kind of rigorous granular analysis that is done in the US. So, by construction, the kind of economic analyses that the courts end up considering in Canada is a lot more theoretical. So, and it's often based on, it's theoretical, but it certainly has to be grounded to the facts of the case. But it is often based on market analyses or public data. And I've just been told I'm almost out of time. So I'll probably need a couple of more minutes. So, so I think, what I want to do, right, in the interest of time is sort of compare sort of the one or more standard in Canada to sort of where we are in the UK, right? And, so this is, maybe a somewhat courageous and hopefully not foolish attempt to do so. But, if you look at sort of Merrick's, as you know, in the Merrick's decision, the claimants put forward an aggregate damages methodology. And the CAT, according to the CAT, right, this was a fundamental problem because the aggregate damages methodology was not based on loss suffered by each class member or most class members, right? And according to the CAT, it basically by using an aggregate damages methodologies, the claimants circumvented an issue which is not common to the class, which is the distribution issue that Liam spoke about, and directly went to just aggregate damages. So, and in the CAT's view, such a methodology would only be permissible if there was a way the claimants had a plausible way of getting back to the calculation of individual loss to class members. And this, so if you sort of put this against Godfrey, the one or more standard, it seems like, the CAT's decision is perhaps a little more stringent than the Godfrey decision, right? Where the claimant expert only needs to know that it reached sort of one or more claimants. But certainly, I agree with Liam, it's a lot more lenient than the US all or virtually all standard. Now, as we know, the CAT did not grant the CPO. The decision was appealed and set aside by the Court of Appeals. And the Court of Appeals actually did accept the aggregate methodology presented by the claimants. And it was more a matter of law, and I'm not going to speak to that, but an implication for the economists is that the claimants don't need to show the aggregate damages results in individual losses, right? Is one kind of possible implication of the Court of Appeals decision. And in that sense, the Court of Appeals decision sets the standard in a place that is perhaps a little more lax than Godfrey's one or more standard. So, I think sort of where we are in the UK is, between the CAT and the Court of Appeals, it's going to be really interesting to see where the Supreme Court comes out. That's where I am, Liam. I hope I didn't go over by too much.
Thanks, Vivek. I've been scaling back my discussion, so I'm sure we'll be fine. Look, I would like to talk a little bit more about certain issues relating to the calculation of damages in the context of a class action. And I'd first make the point that, in general, there's a lot of consistency here with any damages calculation that we would do in different cases, where, as you all know, the governing principle under English law is that damages should equate to the sum of money which will put the party who has been injured in the same position as they would have been if they hadn't sustained the wrong. And in general terms, what we do is we estimate damages in the actual, profits in the actual scenario, and we compare that to what would have happened in the counterfactual where there was no abuse. That's the standard way of calculating damages. Of course, the big difference here is there's more than one claimant and potentially many more. So that raises, important questions as to whether the calculation of damages needs to be accurate for each class member, or whether damages can be estimated at a higher level of aggregation and then distributed to claimants on some reasonable basis, as we've been talking about. And as Vivek has mentioned, there are different standards in different jurisdictions, with the US requiring perhaps greater rigor and precision, and in Canada, where aggregated damages are more widely accepted. And as Liam said, we'll all wait to see what happens with Merrick's and therefore the direction that the UK will go. But putting that, to one side, in my opinion, there's never going to be a simple answer to this, and it's never going to be, one size fits all. Different matters will have different levels of complexity, depending on the nature of the harm, the number of claimants, the level of disclosure, the quality of publicly available information, and of course there'll be other trade-offs that have to be considered. So each case is going to be unique, and the approach to damages will need to reflect those case specifics and the data that is available. Now, in an antitrust context, we need to consider two broad issues. The first is the level of the harm before any mitigation, and in pricing cases, we frequently refer to that as overcharge. And the second issue relates to the ability of the claimants to mitigate their loss through pass on. Obviously, an issue that has recently been discussed by the Supreme Court in the interchange fee cases, and both independently are complex issues. And even if the overcharge could be calculated easily on an aggregated basis, it need not imply that pass on is therefore going to be equally as easy, because pass on, of itself is going to depend on a number of specific issues. Does the claimant operate in a diverse market? If it does, then potentially pass-on rates, will differ depending on factors such as pricing methodologies that have been adopted, the transparency of the overcharge, the level of competition, the nature of the product sold. So, just to remember, there's two issues: overcharge and pass-on, and each will present their own challenges and the approach that is adopted. Now, clearly the number and the heterogeneity of claimants may affect the approach to damages. So small classes may naturally allow a more granular approach. Larger classes might militate towards more aggregated approaches. But even then, such aggregated cases may not be reasonable in complex cases where there are multiple sources of harm. So we'll all be aware of the issues facing Google in the US, where the DOJ has adopted or is alleging several anti-competitive practices. So if one was to imagine a class action against Google, one might find, and I don't know because I'm not working on this case, so I'm thinking out loud, that the nature of the harms will not be common across all potential claimants, right? So, so how do you deal with that? Well, one way you could deal with that is to segment the group to ensure greater commonality across kind of subclasses. So in this example, claimants might be grouped into, by specific abuses, and Google's been accused of affecting the way in which it ranks competitors. There are issues relating to commissions. So potentially that is one way of segmenting the classes to ensure that there is greater commonality across them. Now, there are many different methods for calculating damages. Many of these have been outlined in the EU's practical guide. And a look at recent damages awards across the EU, shows an interesting picture that, in fact, the more simplistic techniques have been used more often. So comparisons over time, so-called before and after techniques, and cost-based methods and comparisons with unaffected markets are the bulk of the cases that have been heard in damages award on that basis. Regression analysis and simulation models have been used much less, perhaps not surprisingly. But how are these choices going to come about? Well, I think experts will have their own preferences. We all have our own favorite techniques, but it's also going to depend on the specifics of the case and the data that is available. Now, in some cases, there might not be an unaffected marketplace, or the start and the end date of a cartel might not be known with certainty. So some of these approaches, can be used in certain circumstances, and in other cases not. Some will be better at calculating aggregated damages, and some might be better at calculating damages at a more precise level. And we've been speaking about regression analysis as potentially being one of those. But regression is fundamentally data dependent, and it requires access to the defendant's data and information, which may or may not be available at the certification stage. And the unknown is, I think for me at this stage, is how courts will respond to such evidence. And it may actually find it difficult to determine which of the regression models it prefers, if any. And as Liam, discussed, the ABB judgment, highlighted the importance of underlying factual evidence and the danger of introducing too much complexity. So, I often, sit back and I think econometric models can quickly become complex, and that often there isn't one model. Oh, yes, I'm now getting a little sign to say I need to move on, and I will. But what I want to say is that the problem with econometrics is that different economists can have completely different views on how to specify the models, and that creates a concern and a difficulty. And one of the examples that I give is that in the regulatory space, Ofwat has developed very difficult and complex models of efficiency for water companies that it says are statistically statistically sound, but actually the economists of the water companies will change a few variables and say, look, they're not statistically sound. And that is a problem that we may face in class actions, battles between economists as to whether or whose econometric models are better. So in my view, econometric modeling is great and should be used, but I think that it needs to be used with other evidence, a so-called preponderance of evidence approach. And the modeling needs to be supported by other damages approaches and by the factual record. So just as an example of that, an economist, when calculating interest, might rely on finance theory to say, well, at the margin, finance theory tells us that interest should be at the weighted average cost of capital. Nobel Prize winners have, put this theory forward, so it must be right. But does it actually always, is it always right in practice? Well, a look at the factual record may indicate that a firm is inefficiently financed, and maybe it has very inefficient levels of working capital. Maybe it carries too much cash on its balance sheet. And if that was the case, then it would be inappropriate to theorize that the marginal rate is the WACC, when actually it's probably the cost of overnight deposits on cash savings. So in conclusion, I would say an economist can't really opine on the relevant standard of damages. That's a legal matter. Each case will be different. It may be that an aggregate approach can be used in certain circumstances, and in others it will not be. In other cases, a more granular approach will be suited, but that increases the complexity of the case. And I think what we must be aware of is that increased complexity does not always yield more precision or greater certainty. That's me.
Brilliant. Many thanks, Greg. Several of the substantive points raised by Liam, Greg, and Vivek on the antitrust side are, in my mind, just as applicable to quantum in respect of other forms of group action. Issues around the abstractness of models, the effective use of data, ensuring analyses is grounded in the facts of a case. These are all, in my mind, equally pertinent for securities cases, such as, for example, the RBS rights issues case or the Tesco accounting misstatement case, and for consumer actions such as diesel emissions or the Lloyd Google case on data. With that in mind, what I wanted to do in my brief section was to talk about first securities litigation and give a very brief primer on what securities litigation is in the UK. Second, just describe some of the core quantum questions that are involved in assessing these securities litigation cases. Third, highlighting some of the challenges faced by experts in addressing these questions, not dissimilar to what the other panelists have talked through thus far. And finally, for completeness, just rounding off with a very brief end note on consumer actions. And I think in this way, what I was hoping to be able to demonstrate is that the various quantum challenges are in fact universal across the class action sphere. And just as we're doing here today, there really is merit in sharing our experiences across the different types of cases. So to start with a very brief primer on securities litigation, provisions in the UK have been in place for quite some time now, but it's only thanks to a Supreme Court ruling in the US restricting action there that has led to litigation finally taking off here and elsewhere. In the UK, there are two specific provisions under FSMA, which is the Financial Services and Markets Act 2000. These are Section 90 and Section 90A. For those of you who are familiar with the US framework, they're roughly analogous to Section 11 and 10B of the US Securities Act and the US Exchange Act. And for those of you who know the European market, then the European directives, then they're similar to provisions set out in the European Prospectus Directive and the European Transparency Directive. At its simplest, what Section 90 does is it relates to compensation arising out of a misleading prospectus, while Section 90A, securities that may have been bought, held, or sold in reliance on fraudulent statements within certain publications. These publications might be, say, an annual report. Now, you'll see in the wording there's a critical difference here in the framing of the two, in that Section 90A cases require evidence of reliance on the publications. And we'll come back to that. Now, in both of these scenarios, 90 and 90A, causation is effectively arising out of the failure to disclose to the market certain pieces of information that would otherwise have had a detrimental impact on the share price. So in other words, what we have is investors who have purchased their shares at an inflated price. Conceptually, this is actually quite similar to the notion of overcharge in a cartel that Greg was just talking about. And the counterfactual here is either that an investor would still have purchased the shares, albeit at a lower price, or that they would not have purchased the shares, perhaps because, say, the fraud involved was so egregious that, would have failed their normal investment criteria. So, for example, things like, not wanting to invest in a company that employs child labor, say. In the case of the latter, the comparison and the comparator is relatively straightforward, because what the loss theory there is essentially the difference between the shareholders' position and what they would have been in had they not acquired the shares in the first place, or what would be left in hand after the sale of all the shares. In the case of the former, however, the exercise is clearly a lot more involved, in that you have to try and determine what an appropriate share price ought to have been, but for the misleading information. In other words, what you're looking for is an inflation per share that can be attributed specifically to the misinformation, or alternatively, you're looking for the true value of the underlying share corrected for these informational deficiencies. Now, this is patently, a non-trivial exercise, because as we know, numerous factors can influence the share price of a listed company. One approach may be to build up a valuation from the bottom up using underlying fundamentals. Complex, obviously doable, but another tool commonly used by economists is an event study. Now, what an event study does is it looks to isolate the economic effect of a relevant trigger event, say, for example, a corrective disclosure or an announcement of a fraud investigation, and it would look at the impact of this trigger event on the share price relative to some sort of reference peer group that would have been unaffected by the event. Now, the choice of this reference peer group is clearly crucial here, because that is precisely what allows you to distill what's normal and what's abnormal in terms of share price movement. So what do you look for in a peer? Similar company, product, market capitalization, all of the above. Whatever you choose, the expert is always open to the criticism of having chosen a peer group that just serves a particular purpose. And how is an expert then to combat that? Well, what I found myself doing more often than not is modeling and testing various options. For example, I'm currently working on a case in the high-tech sector. So what I've done is developed a peer index of similar-sized tech companies within the sector. I've tested performance against the FTSE Tech Mark Index. I've looked at other technology indices. And I've looked at specialist broker analysis and reports as to effective benchmarks and appropriate benchmarks in the sector. And what I'm trying to do here is to just give myself some sort of comfort about a plausible benchmark. Now, similarly, next question, what estimation period should I use? A few months, a year? Again, you want your expert to strike a balance here between the time frame that's sufficiently long to inform your regression analysis, but not so long that you're at risk that the relationship itself is no longer fit for purpose because it's just too far removed from market conditions. In my tech example, various events tied to the product's launch date was critical in selecting the estimation window. So overall, what does this mean? It means, just as in the cartel cases, abstractness in modeling can be a concern, and you really do need to ground your analysis in the facts of the case. The next piece of modeling is turning to quantum itself. A crucial point to highlight here is that these securities litigation cases are all opt-in cases. On the whole, claimants are going to be large institutional investors, pension funds, effectively sophisticated traders. And they'll all have quite sizable holdings. They'll have high volume trades. They will be trading daily probably. And I've now started to see portfolios involving derivatives and hedging positions. I mean, that adds a whole new layer of complexity to the modeling that we're doing at the moment. So over the relevant period, what we may see is that these trades involve the investors having either crystallized their losses or making some gains on those trades. And all of that somehow needs to be assessed, including how those gains should be treated. Now, inventory valuation techniques have given us some helpful and instructive approaches. Things like LIFO, last in, first out, FIFO, first in, first out, weighted averages, netting approaches. Now, obviously, I won't go into the details of those. That's a topic for another day. But irrespective of what your loss theory is or the approach that you use, what is absolutely fundamental here is that you're doing granular trade by trade analysis. You're matching the trades. And why are you doing this? You're doing this to ensure that none of the claimants in your group are over or under recovering. And again, this bears similarities to the antitrust world. I mentioned that we're at the early stages here in these cases. I mean, there have been a number of noteworthy cases. I mentioned the RBS and the Tesco cases. There's unfortunately no UK case law at the moment, though. For those of you who are familiar with Australia, there was a recent judgment there in relation to Myer Holdings, and they accepted the merits of an event study, but they have yet to go to the modelling of loss. So overall, we haven't really got anything where these approaches have been tested in court. And that makes it, yep, I'll be done in a minute, Liam. That makes it, particularly useful to draw lessons from elsewhere. For example, the antitrust world. And then, so finally, I mentioned I would like to end with a brief endnote on consumer actions. The challenges, again, are similar along the lines that the panel has touched on: commonality, homogeneity around claimants, when you're looking at certification, disaggregation of data. If you take, for example, a diesel emission case, what types of, how do you treat different vehicle purchasers? Take, for example, a data breach case. Can you fill gaps about individuals' views on their personal data using survey evidence? And if so, how do you ensure the survey stands up to scrutiny as an expert? Again, all non-trivial questions, but hopefully ones where the antitrust world can help shed some light. So in conclusion then, all I wanted to say was, I think, this is all really early days. It's a case of watch this space. And let's keep sharing our experiences. It really does help.
Thanks very much, Tasneem. I think we've just got maybe just a couple of quick minutes, Gordon, if we can, just to...
you guys can continue for a couple of minutes because we started a bit late.
just one question. Actually, Tasneem, there is seems quite a technical question for you on the chat, which perhaps you can follow up bilaterally. I have a quick question for folks. We didn't touch on whether there's any scope for taking into account the illicit gain of the defendants in any of these cases. Obviously, you know, in a case where there are both direct and indirect purchases, that doesn't really help you very much if you're bringing one of those cases. But I just wonder, and whether indeed in consumer actions, whether that evidence has any role to play. Perhaps just a quick fire round the panel, yes, no, maybe, and any quick illuminations you can make on that point. Vivek, can we start with you? Are you still thinking? Greg, how about you?
He's trying to unmute, I think.
Yeah, you're on mute, Vivek. Still on mute. Craig, why don't you have a go?
Yeah, I don't know. I've been thinking about this a little bit. I'm still kind of puzzling whether this is a question for an economist or whether it's a legal issue at the end of the day. You know, my view is that the economist or the expert is well placed to calculate such gains or total damages. You know, there's then a question around distribution and whether things can be distributed, and if they can't, what you then do with those undistributed gains. And I think that's why I come back to say, you know, that legal question. I mean, economists can talk about mechanisms, but I don't think they can really advise on the legal policies.
Sure. Yeah. Beck, are you with us?
Yeah, no, sorry, my mute button was not working for some reason. I don't know if I have anything to add over what Greg just said, to be honest.
Okay. Tasneem, any insights from you?
I concur with Greg also, not least because in the cases that we're looking at on the security side, the treatment of gains it has been quite a challenge, and the gains can be material. So trying to decide what to do with them and how to account for them matters. But again, I think it's a case of waiting to see where case law comes out on that.
Yeah, I would agree. I think it's a legal question which can dominate, but back to our earlier point, if we are allowed to look into things and we think they'll be helpful, as economists, we tend to think we'll be able to have a crack at it. So look, why don't we stop there? And obviously, people can reach out to us separately on the networking panel, and we look forward to further discussions. Hopefully that was informative and useful for folks in the audience. Thank you.
Thank you very much, everyone. Thank you, Tasneem, Vivek, Liam, and Greg. And please feel free to continue networking afterwards. And the guys, as Liam said, are open to questions. Reach out directly, make use of the platform.
Thank you.
Perfect.
Thank you.
Bye.